for being here again for the next episode of our Friday weekly podcast, the Class Action Weekly Wire. I am Jennifer Riley, partner at Duane Morris. Joining me today via Zoom are my colleagues. First, my colleague and fellow partner, Michael Demarino, and secondly, my colleague and associate, Tyler Zmick. Thank you both so much for being on the podcast this week.
It's great to be here. Thanks.
Thanks for having me, Jennifer.
Today, we wanted to discuss some trends and some important rulings in the area of appeals in class action litigation. What were some of the most significant developments related to this area in 2022? Michael, can you address that?
Sure. So appeals in class action litigation, whether they're involving a trial court's interlocutory order or a final decision, were a key focus for class action plaintiffs and defendants alike. For plaintiffs, counsel may wish to appeal decisions denying class certification or decisions that grant class certification, but as to a limited subset of the plaintiff's proposed class. And for defendants, we saw the opposite. They often wish to immediately appeal an order granting class certification and try to hedge off what could otherwise be a very expensive and tedious litigation.
And bouncing off of that point, parties really have limited options when it comes to seeking interlocutory appellate review of a class certification decision. The primary mechanism that most parties use is Rule 23F of the federal rules. And under that rule, a party must file a petition for permission to appeal with the circuit clerk within 14 days after the order is entered. That is the protocol in the majority of cases.
Yeah, that's right. And I would just add that parties can also seek interlocutory appellate review of a district court's decision that involves class certification, in addition to a broader array of decisions issued in class actions under 28 U.S.C. Section 1292B. Section 1292B appeals are especially helpful in complex cases to correct early errors on questions of law that, if were left unattended or uncorrected until final judgment, might otherwise require the parties to do years of expensive and time-consuming litigation.
What are the primary differences between those options?
That's a great question. Unlike an interlocutory appeal under 28 U.S.C. Section 1292B, Rule 23F is a little more streamlined insofar as it doesn't require the district court to certify an issue for an appeal. In other words, appellate review is basically discretionary and left entirely up to the Circuit Court of Appeals. Another important difference is that Rule 23F does not include the potentially limiting requirements of Section 1292B, under which the district court really can only certify an issue of appeal in narrow circumstances, where specifically where the order involves a controlling question of the law as to where there's a substantial ground for difference of opinion, and where an immediate appeal from the order may materially advance the ultimate termination of the litigation. So 23F doesn't have that built-in standard that Section 1292B does.
And how successful generally are those petitions under Rule 23F?
Not super successful. So studies show that appellate courts deny about 70% of Rule 23F petitions to appeal class certification decisions. Unfortunately, most of those denials are accomplished via summary order. So there's no published or unpublished opinion. In fact, we only really see a published or unpublished opinion explaining the reasons for a denial around 10% of the time.
Do you have any examples of rulings where these petitions were granted over the past year?
Well, I'm glad that you asked that, Jen. I think one good case that comes to mind is a very interesting one called In Re EI DuPont C8 personal injury litigation. And basically, the plaintiff in that case sued manufacturers of chemicals called PFAs, which are at this point in time so widespread that they can be found in the blood of pretty much every person in the United States. And so the plaintiff claimed that exposure to PFAs increases the risk of diseases like cancer. And he asserted nationwide tort claims and sought certification of a nationwide class of over 330 million people, basically all Americans. The district court granted certification, a limited Ohio injunctive relief class under Rule 23b2. And while that was a limited class based on, relative to what plaintiff was trying to seek certification of, there were still 12 million Ohio residents in that class. And the district court also expressed a willingness to certify similar classes from other states that recognize the viability of the medical monitoring remedy. So that was a pretty extreme, some might say, class certification decision, and it led to the defendants seeking interlocutory appeal of that class certification order. And the Sixth Circuit granted the petition, and in doing so, it went through the standards that apply to a petition for Rule 23F interlocutory review. And the court articulated why the panel believed the defendants should prevail in their appeal, including further review as to whether the plaintiffs had Article 3 standing and whether the class met the commonality requirement.
There's actually another good case that is an example of a court granting a petition to review under Rule 23F. And that case is Lodato et al. Versus EQT Corporation. And there the plaintiff sought compensation for the defendant's use of plaintiff's underground space for storing natural gas and sought to certify a class of similarly situated landowners. Well, the district court found class certification appropriate, but it did so with a modified class definition. So the district court didn't accept plaintiff's proposed class and instead ordered the parties to meet and confer on the definition of the class. Well, the defendant petitioned for appellate review under Rule 23F and essentially argued that the district court erred in its class certification ruling. And plaintiffs responded that the petition should be dismissed as premature because the district court's order was essentially preliminary and didn't actually grant class certification. Well, the Third Circuit said no. It rejected that argument, and it stated that the district court plainly contemplated that any subsequent certification order would be limited to merely redefining the class. And it was important that the Third Circuit actually noted in its petition that because of the apparent pressure purported certification places on a defendant to settle, and because of the court's opportunity to facilitate, development of the law on class certification, that it would consider it would hear the appeal and consider the Rule 23F petition.
Those decisions are very interesting in terms of the different rationales that the court used in granting Rule 23F review in those cases. Can you think of any notable examples of rulings that denied Rule 23F petitions over the past year?
Yes, I can speak to that. There's one case that comes to mind, and it actually contrasts with the last case that I was just talking about, the Lodato case. And this case is Grupo Televisa et al. Versus Palm Trans Inc., Amalgamated Transit Union Local 1577 Pension Plan. It's a mouthful. And in that case, plaintiffs were investors who alleged that the defendant had bribed the Federation Internationale de Football Association to secure rights to World Cup games. And the district court initially denied plaintiff's motion for class certification because the proposed representative was not typical of the case. but shortly thereafter, they found a new class representative, a transit union pension plan, and they were able to secure certification with their new class representative. Well, the defendant sought an immediate appeal to the Second Circuit, and it argued that it faced hundreds of millions of dollars in potential liability stemming from, an improperly long class period. And unfortunately, the defendant lost its argument for immediate review of the class status of the investors. And notably, the Second Circuit stated in a one-paragraph order that an interlocutory appeal is not warranted. Marking the second time the Second Circuit has declined to intervene in class certification decisions in this case. And so, in contrast to the Lodato case, the pleas that class certification ruling is going to, drastically extend the litigation and increase exposure on the defendant, it fell on deaf ears within the Second Circuit.
And I think another notable ruling in 2022 denying a Rule 23F petition took place in MasterCard versus Skoma Chiropractic. And in that case, the 11th Circuit explained its denial of a Rule 23F petition. So it wasn't one of those summary orders that Michael mentioned earlier. And the 11th Circuit noted that it considers the following 5 factors when deciding whether to grant interlocutory appellate review of a district court's class certification decision. And the 5 factors are: 1, whether the district court's ruling is likely dispositive of the litigation by creating a quote-unquote death knell for either the plaintiff or the defendant. 2, whether the petitioner has shown a substantial weakness in the district court's class certification decision, such that the decision likely constitutes an abuse of discretion. 3, whether the appeal will resolve the unsettled legal issue that is important both in this particular case and in and of itself. 4, the nature and status of litigation before the district court. And 5, the likelihood that future events may make immediate appellate review more or less appropriate. And in denying the defendant's petition in that case, the 11th Circuit held that the defendant failed to satisfy any of those 5 factors.
I would also just add that there were 3 opinions by the Sixth Circuit about within a week period in June of 2022, in which the Sixth Circuit explained its basis for denying the separate Rule 23F petitions. The first case is one called Ahrens et al. Versus Family Solutions of Ohio, Inc. And there the Sixth Circuit explained that a Rule 23F gives it unfettered discretion whether to permit an appeal, akin to the discretion exercised by the Supreme Court in acting on efficient certiorari. And in that case, the Sixth Circuit ultimately rejected the defendant's contention that the appeal presented novel issues and that the defendant was likely to succeed on the merits, and that review was appropriate to prevent the incursion of unnecessary costs and in litigating the case for years. The second case was similar. That case was Ray Macy's West Stores, Inc. And there the Sixth Circuit again described in similar terms its standard of review regarding 3F petitions, and it found that issue was not sufficiently novel to warrant a Rule 23F appeal. So in both those decisions, the concept that the issue before the court was not novel was a factor that led to the Sixth Circuit's denial of the reviewing the Rule 23F petition.
Yeah, and the third decision issued by the Sixth Circuit that week of June 2022 was in a case called In Re Ascent Resources Utica. And in that case, the Sixth Circuit basically elaborated further on the standard and the 4 factors that Mike mentioned being described in Ahrens and Macy's. And in the In Re Ascent Resources Utica case, the defendant argued that its Rule 23F petition should be granted based on the death knell factor, because the risk of $19 million in damages threatened its entire business model and really resulted in the creation of undue settlement pressure on the defendant. The Sixth Circuit rejected that argument because the defendant's statements were devoid of context. Basically, they did not provide enough detail as to the quote unquote death knell factor.
Thanks so much. Those are some great examples. Are there any notable rulings involving appeals under Section 1292, particularly over the past year, that you can think of?
Yes, absolutely. And I think the most important appeal under 28 U.S.C. 1292B was in a case called In Re A&L Home Care and Training Center. The defendants in that case succeeded in obtaining interlocutory appeal under Section 1292B, and they did so on an issue of crucial importance in the class and collective action context. So the case involves the widely used two-step framework for deciding whether a proposed collective action should be certified under the FLSA. As I'm sure most of us are familiar with, this standard, it involves the initial conditional certification stage, and then later the more robust stage where a defendant will usually move for decertification of the collective action after discovery. So in the underlying matter in this case, Holder versus A&L Home Care and Training Center, the district court conditionally certified 2 of 3 proposed FLSA collective actions. And the defendants asked the district court to join the Fifth Circuit in abandoning the two-step framework, which the district court denied. Regarding the Fifth Circuit, they basically are the one circuit in the US that has strayed from this two-step FLSA conditional certification framework and really proceeded with a one-step robust certification standard. And importantly here, the Sixth Circuit accepted interlocutory review of the decision after the district court certified the two-step framework. And so the Sixth Circuit found the issue worthy of immediate attention under 1292B, and it remains to be seen whether the Sixth Circuit will join the Fifth Circuit in that regard.
What an interesting decision. We'll certainly look forward to hearing about the Sixth Circuit's ruling in that appeal. What else do you guys think that corporate counsel and employers should be on the lookout for in 2023 or during the upcoming year?
Well, I think that appeals will continue to be granted sparingly. There's nothing I've seen that suggests that trend will change, at least not immediately. Courts of appeals will continue to provide guidance to both sides as to what will and what won't be successful in terms of arguments in the petitions. And of course, the parties are going to push the envelope, and novel approaches will continue to develop from both sides, and they'll evolve their strategies in order to obtain success in securing the appeals.
Great. Well, again, thanks so much for all of the great analysis that you all provided today. Michael and Tyler, thank you for being here with me. Listeners, thank you for tuning in. And if you have any questions or comments on today's podcast, please send us a DM on Twitter at DMClassAction. Thanks again.
Thank you.
Thank you.